Today our topic is really just about how things have come to be in the past and the evolution of advanced care planning and some of the really important cases that have led us to where we are today. It's amazing that we can hear this, and if you put time frames into it, I'm going to try to give you all kind of a taste of that, how recent this really is. And as we look into kind of humorizing this just a little bit, we recognize that this is something that is very difficult to talk about, something that's very difficult to even have that concept when you're talking about your family, your loved ones. But actually, I took this clip from the famed philosopher Woody Allen. It says, "I'm not afraid of death. I just don't want to be there when it happens." And unfortunately, that's what happens a lot of time in the absence of advanced care planning. But why are we here today? Why is this so important? Why should we care? Let me give you a couple of quick reasons which I thought you might find interesting. First of all, the fact is that many of you may not know is that at the end of life, numerous studies have showed that 75% of patients will be unable to make some or all of their decisions for themselves. So by that time that you get really seriously ill, 75% or 3 out of 4 times, we will not be able to ask you because you simply cannot tell us. And what's worse is that we often don't prepare patients or their families to deal with the difficult or emotional situations before they arise. I can share with you as a palliative care nurse that the worst time to have these discussions is in the ER or in the ICU in the middle of a crisis. This is not the time to say, gee, I think we ought to bring this up right now. And, families don't even know that it's coming. Sometimes it's like a freight train that hits them. And hence the need for advanced care planning or planning in advance of a healthcare crisis. Secondly, I'd like to kind of talk to you about something that I particularly found interesting, is that most of those same studies show that doctors, no matter how long they know their patients, really don't know what their patient would want at the end of life because they don't ask. What's more important, families often don't know what their loved one wants. And patients don't even know what they want because they haven't been given realistic expectations and an opportunity to discuss how they would react, what they would want in any particular circumstance, especially when they're critically ill, where things will be changing at a record pace. It's pretty interesting that unless a meaningful and clear conversation with the patient has happened, we have no idea what they want, and how do we get to that today? Let's just do a quick little historic review, and I know this is probably more than you'll want to hear, but it's important because each one of these pieces in a very short period of time, we're talking about from the 1960s forward. That's a short time in the evolution of healthcare. Really, looking at these factors, they all happen simultaneously. That's one of the things that has been actually a benefit to this evolution, as opposed to a barrier to it. I just want to start with a little bit of background. Prior to the 1960s, most decisions about end of life were negotiated with families and the primary physicians, either in the office or in the home. And they mostly focused on quality of life and pain and symptom management. Your great-grandparents, I won't say grandparents anymore because that's a whole different generation, but your great-grandparents did not have to make the decisions that you're going to have to make in the future. The truth is, they lived hard. If they got sick enough to where their heart and lungs failed, they died. There were no ICUs, no heroic measures. They were not asked to make those types of decisions. So let's talk about what happened in the early 1960s that changed the tide. Prior to the 1960s, hospitals did not have ICUs. And why was that? Because technology had not grown yet. Major advancements in new technology, including advanced life savings and supporting medications, defibrillators, cardiac interventions, and all those other procedures allowed for the opening of specialized units focused on caring for our sickest patients. Now, equipment like ventilators that were traditionally only used in the operating room or post-operative were now available to use in these new units. And widespread use of these interventions that were never intended for patients with life-limiting disease processes were being used, but during this evolution, something changed. It changed from the intention of being used for life-saving, for treatable patients that you could return to a previously healthy state, to being used for treating patients toward the end of their life. And it became a standard of care for all. Around the same time, the Boy Scouts of America, as part of their first aid handbook, brought to attention a procedure called CPR, or cardiopulmonary resuscitation. The intent of CPR, which I must say is not a passive act. If anyone's ever seen it on a production on TV, you see that they do a little pumping and they do a little breathing, and the person sits up and they go home the next day. It's nothing like that. CPR is not a passive act. It was not intended to resuscitate the person who had a chronic life-limiting disease process. It was really meant to resuscitate a previous healthy person who was a victim of electrocution or drowning. And that is how it's posted in the Boy Scouts manual. But through extensive efforts to educate the public, it became a standard of care for anyone who has an incident where their heart stopped or they stop breathing, whether they're in the community or in the hospital setting. This brings us to the code blue in the hospital. Originally, it was never meant to keep people with progressive diseases alive. And in the absence of a do not resuscitate order in the hospital, we do CPR and intubate ventilation on everybody in the hospital that stops breathing, regardless of his or her condition. Now think about that. Think about the vast array of patients that you have in the hospital. Everyone from the newborn to the pediatric to the 99 or 100-year-old patient who comes in with the end-stage disease. If they stop breathing, everyone receives the same treatment no matter what. No one dies in the hospital without these interventions, unless you and your doctor have had a conversation and the doctor puts in an order for no CPR or a do not resuscitate. I know this might seem backwards, that you have to put in an order to not do something, but to this day, it's the only intervention that you get in the hospital without a doctor's order. Think about it. You can't get a Tylenol. You can't get a glass of water. You can't get a meal without an order. But everyone gets CPR, regardless of the patient's condition or prognosis, unless you or your doctor specify that you don't want it. So let's go for a minute to some of the landmark cases that influenced the creation of some of these laws and the documents that followed for us to be able to follow. The first case I'm going to review is the case of Karen Ann Quinlan, 21-year-old. She's the first right to die case in this movement that started in '75 and ended up in 2005. It took that long for us to be able to evolve this to a place now where this is undisputed right of patients to make decisions for themselves. Karen was the first case. Like I said, she was 21 in April 1975 when she was out with some friends at a bar for one of their birthday parties. She had a couple of drinks, took a Valium. She started to feel faint, and her friends took her home and put her to bed. About 15 minutes later, they realized she wasn't breathing. They called an ambulance. They gave her mouth-to-mouth, which they didn't have CPR at the time, or a CPR, the friends didn't know it. And she was taken to the hospital where she was placed on a ventilator with oxygen. It was determined a few days later that she was in an irreversible coma and was not going to recover. This is a 21-year-old young lady, previously very healthy. The Quinlans struggled with this decision. Then they turned to their very strong Catholic roots, and along with their counsel from the church, decided that their daughter would never want to live this way. They requested that the ventilator be removed. And let's quickly go through this timeline. April 17th, found not breathing. Parents petitioned for removal in September. when the first case went to the county court, it was told that she could not be removed because the parents' request was no more than euthanasia for this young lady. The Quinlans took the case to the state court, who actually agreed with the Quinlans and said they could remove the ventilator. At that time, the hospital, on the other hand, took the case up to the New Jersey State Supreme Court, who ruled that Karen could not be removed. The family appealed back to the State Supreme Court of New Jersey, which was the first case of any of this kind, and they were granted the right to remove the ventilator. Think about the torment this family went through, having to fight in court to say what their daughter would want. They removed the ventilator, and Karen lived for another 9 years on artificial nutrition and hydration, where she eventually succumbed to complications of pneumonia and passed away peacefully. Even though this was a fight, there were some precedents that were set. The first one was really the creation of bioethics committees in hospitals, nursing homes, home health agencies. This was really important because the Quinlans, as this evolved, asked for help from other people in the medical community. There's where the bioethics committees were developed. It also established the patient's right to refuse medical care or control his or her own medical treatment, and creation of advanced care directives and healthcare proxies. Prior to this point, whatever a doctor thought, the family would have to argue. What the hospital thought, obviously in this case, the family had to argue. It always became an issue of arguing over who was right about the care for your loved one. Here's the second case. This was started, the accident was January 11th, 1983. So we went from 75 to 83. Nancy Cruzan was driving down a country road in Jasper County, Missouri, when she lost control of her car. She was found by a passerby in a ditch, face down in water, after an unknown amount of time. She was not breathing and had no cardiac function. Paramedics were called and were able to restore circulation, but she sustained a significant amount of time without oxygen to her brain. She was admitted to the hospital in a dense coma, and she remained in that coma for about 3 weeks when the doctor declared her in a persistent vegetative state. PVS, or persistent vegetative state, means that she has adequate function to continue breathing and heartbeat, but has no cognitive function, or what makes a person who they are. She had no ability to follow directions. She was unable to eat or drink, so they placed her on a feeding tube. She was not on a ventilator, so she didn't require that type of intervention, but she remained in that persistent vegetative state. After talking to her roommate and friends, it was discovered that she had had many conversations with them, stating, if I was ever in an accident and was ever a vegetable, I would never want to live that way. How many people, young people, have made that comment to someone else? This is one of the pivotal pieces that was trying to be argued in the courts. Timeline once again, January 11th, 83. After 2 years of intensive rehab, it became apparent to the family that she was not going to regain any kind of physical or cognitive function. They asked the hospital to remove the feeding tube, to which the hospital employees refused. The family argued that Nancy's wishes were clear by her previous conversation, but the hospital said no. The family took the case to the Jasper County Judicial Court, who agreed with the family and ruled that the tube could be removed. Once again, think about the torment to the family. 2 years of watching their daughter in rehab decline to a place where she was lying, contracted, unable to move, and the court said, yes, you can remove the tube, and the hospital appeals to the Missouri State Supreme Court, who once again overturns the lower court's decision, saying, yes, and this is important, yes, we agree that every patient has the right to make decisions for themselves, but only if they are able to make decisions for themselves. And obviously, she was in no condition. Okay, now the family appealed back to the U.S. Supreme Court. This is the first case on the right to die that was ever heard in the U.S. Supreme Court. And the court, after reviewing everything in a split vote, agreed to back up the state Supreme Court and uphold the ruling to not allow removal. Even though the family technically lost this, several statements were made along the way that have changed the way that we look at healthcare. The first precedent: all interventions, including nutrition and hydration, are medical treatments and can be refused. Number two, people have the right to refuse, but if they are unable to tell anyone, each state must decide what level of evidence is necessary to provide that statement, or to prove that statement. And this sounded really confusing to everyone. They went back and they said, okay, Missouri, now what are we going to do? To this day, each state still has the right to determine what level of evidence proves the case. So let's talk a little bit about the three levels. First one is, and you might have heard this in a lot of court cases or in movies, a preponderance of evidence is about 50% proof. This is, an example of this would be when someone says, I know my daughter and I know she wouldn't want to live like this. I'm the only one who has had conversations with her before, but you know what, she's never really told anyone. I just think I know what's best for her. Most states won't accept that. Second level, clear and convincing evidence. That's about 75%. Now, to me, when I was looking through this, clear and convincing sounded like a lot. A lot of states do accept that. An example of that is if possibly this young lady had talked to her doctor, told her friends what her decisions were, which is what happened here. Maybe the doctor documented it in his chart that says, you know, this 80-year-old person with end-stage disease, we've had the discussion, and she would want full treatment, but never to be on a ventilator or on life support. That's 75% clear and convincing evidence. Now let's move down to the last one, without a shadow of a doubt. This is 100% proof. It's when you make a decision, when you put it in writing, you make a legal document, and you give it to the people who are going to be able to speak for you. This is an advance directive. This is a post form. This is a living will that has a portion in it that talks about what your wishes at the end of life would be. Without a shadow of a doubt, 100%. The U.S. Supreme Court also made statements that led to the next piece, which is the Patient Self-Determination Act of 1991. It requires that patients be given information about advance directives and healthcare proxies any time they enter a healthcare agency. That's hospitals, nursing homes, hospices, home healths. They have the right to facilitate their own healthcare decisions. They have a right to accept or refuse medical treatment. They have a right to make an advance directive, and they have a right to name a proxy to make these decisions for them if they are unable or if they choose to have the proxy start right away. The Patient Self-Determination Act encouraged everyone to decide now about the types and extent of medical care they would accept or refuse if they became unable to speak for themselves. In reality, when people end up in the hospital, like I said before, most people, 75%, in this state are not able to speak for themselves. The Patient Self-Determination Act is to inform patients of their legal rights and encourage them to make plans for themselves. Let's go on to the next case, and this one probably was the most confusing for everyone. So you have 1975 is the first case, 1990 is the second case, ended in 1990, I'm sorry, with the decisions. This one started in 1990, and I think this is probably the one that most of us know more about. Young Miss Terry Schiavo, a married young woman, 26 years old, who had an eating disorder. She was anorexic. She was healthy otherwise. She had been on a pretty strict eating plan, in her words, where she had very low potassium and calcium, and her electrolytes had shifted enough to where she had a cardiac arrest in her home. Ambulance was called. She was successfully resuscitated, but due to extensive brain damage and lack of circulation, Terry was left in a comatose state, and after 2.5 months without improvement, was determined to be in a persistent vegetative state. For the next 2 years, her husband, who was appointed her guardian, attempted experimental therapies, extensive physical therapies, took her in for brain stimulation. He tried everything, took her to numerous specialists. And in 1993, he placed an order for a do not resuscitate after she had a pretty significant urinary tract infection, saying that if, as her guardian, once again, she was named as her guardian, he was named her guardian, that if she had an event, that he would want to allow a natural death. In 1998, so this was 8 years later, her husband petitioned the court to remove her feeding tube. This started a very long course of 14 appeals and numerous motions, including 5 federal lawsuits, extensive political interventions at the Florida state level, including Governor Jeb Bush and eventually President George Bush, to intervene in this case. This case also spurred highly visible activism from the pro-life movement and the right to die movement. So now we've got the political side stepping into this. And through all of this, the disability rights movement also got involved. During the proceedings, there were some 18 witnesses of Terry's friends who said that she had told them she would never want to be kept alive without a chance for meaningful recovery. And the doctors had determined she had no chance of meaningful recovery. So we're looking at this timeline. 1990, husband petitioned in 98, 8 years later, after an extensive trial. 2000, the parents of Terry Schiavo filed multiple motions to block removal. This was the first motion to block the removal, and they removed it because the court said yes, they could. A day later, the parents went back to a higher court, got an injunction, and they reinserted the tube. In 2003, in October, the second ruling for tube removal, which they removed it, was overturned by the new Terry's Law, and it was reinserted. This is a law that the parents drafted with the help of patients from the American Civil Liberties Union and the Disabilities Privacy and Rights Act. Okay, let's go back to this. In 1992, let me back up just a little bit. One of the things that I didn't put on here that kind of tweaked me just a little bit as I looked at this is that political power and the strife that happens between family members when they don't agree on things. In 1992, Terry's husband, Michael, filed a malpractice suit against Terry's OB, citing that he failed to take a complete medical history that would have revealed her eating disorder, which ultimately led to her cardiac arrest. He was awarded $6.8 million by the jury, which was later reduced to $2 million, still a significant amount of money. And after the attorney and court fees, the final accounting was $300,000 for Michael and $750,000 in a trust for Terry's medical care. According to Michael, in his book that was released later, in the early 2003, the parents demanded that he share the malpractice money with them. So this is another portion of that kind of threw a twist into this timeline for her medical treatment. In 2004, the Florida Supreme Court struck down Terry's Law as unconstitutional. In 2005, the husband once again petitioned to have the tube removed. This is where the political schemes got involved in this. This became a partisan issue where the Democrats were fighting the Republicans, and the Democrats wanted to allow this to go through. The Republicans wanted to fight it for a right to life. Palm Sunday compromise is what they call it, showed that the case was transferred to a federal jurisdiction. Then President George Bush flew in from Texas to DC to sign this law into act at 1:10 in the morning, because it didn't have to happen in a court setting. It didn't have to happen with an official vote. They called a vote of the people that were available. They voted on it. They made this Palm Sunday compromise. This led to a huge standoff. First week of March to March 24th. The judge in the federal court looked at it again within that week and made a final petition. He denied the ruling of the Palm Sunday Compromise, leading to a police standoff between the state and federal troops. You have state troops that are trying to back up the state order. You have federal troops that are backing up the federal order, and they're standing outside of the house, the hospice house where Terry's being treated. This was all over the news. It became a huge spark for a lot of Americans who really didn't know much about the right to life or right to die movement. And this was highly politicized, highly televised, and it was the first that really struck a chord with most people. The troops, after reading the final judge's precedent, the state troops stood down, the federal troops stood down, the feeding tube was removed, and she died peacefully about 5 days later. This was 15 years after the incident that Terry Schiavo died peacefully in the hospital. Some of the highlights and the precedents that were set highlight the federal involvement in end-of-life matters, that states are saying that they have the right to make the decisions, and to this day, states remain the ones who are in the driver's seat because of this, the kind of the end-of-life options with that Palm Sunday Compromise fiasco. It raised awareness of the right to die options as emotional and difficult for families. It made multiple political action committees, ones that really were just basically getting off the ground, grabbed a hold of this, and boy, they just came out of the woodwork. And early work from these cases really, in this case in particular, created the evolution of the Advanced Care Planning documents and the Death with Dignity Act. Just to summarize this, these were three very difficult cases of young people who shaped our current decision-making policy. These were not 80-year-olds or 70-year-olds with chronic disease that should be having these conversations. These are the most far from the norm as possible. And I hope that you all know that an advanced care directive can be executed on anyone who's 18 years or older. And part of what we will do in the future is go through and talk about some of the kind of the times to have these conversations, how to have them, what the forms look like, how to operationalize them legally. But these are intended for anyone over the age of 18. One of the things that came out of this really is that each state has its own legal tools for documentation, and we need to be aware of those within your state. Americans will live to an older age with multiple comorbidities, and these conversations really need to happen. Advanced care planning is imperative to have your healthcare goals honored and to make sure that your family is left with a legacy that is not of discord or discontent, and that they know what you want so that they can help and honor what is a natural part of life. So where do we go from here? I've given you guys a lot of information on this pretty extensive but short-lived evolution of where we came from the 1960s to now. Where we go from here is the important part. How do we reach people, and how do we get this message out that laws can change, and if we don't speak up for ourselves, for our families, for our loved ones, that being an advocate will do no good unless you follow through with it. So I will entertain any questions.
Diana, I don't have any from the chat at this time. If anybody would have one, you can unmute yourself and ask Diana. Diana, that was exceptional. I've been doing this for a long time, but I've never heard it in that detail, and I learned some new things. Thank you so much. That was exceptional.
I think it's really important that we know where things came from, especially if we're going to be the advocates for this. We know that this wasn't just something that someone came up with and some lawmaker agreed to it. This was a hard-fought battle at the torment of a lot of families. And these are just 3 of many, many cases. If you look online, there is a list of other cases that led to all of these other actions. And in the face right now of California having a Death with Dignity Act, or that right for someone who's terminal to end their life, not all states have it. Not all states agree with it. And not all states even have a form like a PULSE form, which we will describe in a future lecture, to talk about your healthcare wishes documented as an order after having a thoughtful conversation with your doctor.
Great. If anybody would like to ask an oral question, I don't have any typed ones, but unmute yourself, because I went through to make sure everybody was muted when I was hearing sound. So you may need to unmute yourself if you'd like to ask a question or have a comment. You're very welcome to do that and participate. We'd really appreciate it.
I have a question, Diana. So, and thank you, that was awesome. I didn't know all of those different cases. I heard a little about the Terry case, but not to that detail, so.
It's because you're too young. Sorry, you make me feel old.
But my question is, so from that's advanced care planning, how did we get from that to evolving to PULSed? And why do we need PULSed if advanced care planning states their wishes? Why do we need both?
Okay. You know what? That is a matter of a legal documentation and how to evolve from the original advanced care health care decision proxy, which is an advanced directive, allows you to name someone to make a decision for you if you can't make a decision for yourself. It's a notarized or a witness document that is a legal document. It can be part of a living will, of a proxy for healthcare, or a power of attorney, but it only names someone to make a decision for you if you're unable. What a PULSE form, which is a physician's order for life-sustaining treatment, is actually a doctor's order that is portable. It's like having a prescription that says, my doctor and I have had this conversation. The doctor signs it, the patient or the proxy signs it, and it says, we've talked about these 3 things. The first one is, if I am found down, I'm found with no pulse, and I'm not breathing, I have died. What intervention would I like done at that point? Would I prefer to allow a natural death? Or would I prefer cardiac resuscitation, a ventilator, and cardiac interventions? That's the first one. So you've been found down, you're not breathing, you have no heartbeat, you're not suffering, you have died. What intervention would you expect out of healthcare or the public?
Right, but if you've already put all that in your advanced directives.
Well, the thing is, an advanced directive is not a legal doctor's order. If you think about it, an advanced directive is part of a multi-page document that think about the incident where a EMT comes into the house. Your husband is down. He has a living will or an advanced directive that says you're a decision maker. And do you think the EMT is going to stop and shimmy through those paperwork to find out what they want? They could put on there, do not resuscitate and do not, but it's not a doctor's order. By law, what I said in the beginning of this, the standard of care is that everyone receives it in the absence of a doctor's order.
So even if you have the advanced care directive, if the
absolutely, the advanced, it says what you would want, but it's not an order for them to stop. And I have actually seen families and heard of families that got pushed out of the way and said, I'm sorry, that's not enough. We must do what we have to do.
How did we get to the point where we decided we needed that? That's where I guess I'm going with that, is the history.
Yeah, well,
Our professionals here, and most of us know this like briefly, but I would be interested like where that case, what switched us from, or made us realize that we couldn't just have an advance directive, we needed a doctor's order.
that actually happened in 2001, where the California, or actually Oregon Coalition for POLST came about that said that too many people that had already stated their wishes, since it was a standard of care, too many people had already stated their wishes, there was a big confusion. When an EMT comes in, do they do it? Do they not do it? Do they honor the family who says, here, look, I'm the decision maker? Or do they just push that person aside and say, I have no doctor's order, I must act in the case of an emergency? There was too much confusion and too many people's wishes were not being honored. State of Oregon developed this form. They've been using it since 2000. We initiated it here in California in 2001. So it's been in place for a long time, and a lot of people don't even know about it yet. But what it is, it's a portable order that says that if you, no matter where you enter, they take that order from the doctor, whether it be into the hospital, into the service of an EMT in your home, into a nursing home, into home health, that they will all honor that as your wishes prescribed by a doctor, to clarify confusion.
Diana, Laura would also like to speak to this. Laura, are you there? CW 9569. She said she wanted to speak to it, but she's not coming up here.
Can you, I'm on the phone. Can you hear me?
We can.
Okay, good. All right. So I think, Lindsay, the thing I wanted to say is that if you read through the way an advanced healthcare directive is written, it'll say under the choices, if I have a terminal illness and I am not expected to survive, or if I have in a persistent vegetative state or in a unresponsive state and to a reasonable degree of certainty I am not expected to survive that, or if the burdens of the care outweigh the benefit to me, then I choose A, to prolong my life no matter what, or B, I choose not to prolong my life. In an emergency setting, a paramedic has no information about those qualifying issues that the patient is experiencing. So really, the way we say an advance directive is a guide to the decision maker. It is not something that in an emergency situation anybody can follow because they don't know if that person meets those things. So that's why I say when I'm talking to families about it, that the advance directive, the most important thing the advance directive does is identify that decision maker. And then hopefully they'll continue to have discussions about those qualifying things so that the decision maker knows how best to honor their loved one's wishes. But in an emergency, that POLST form gives clear guidance exactly on what they want. So that's why we also say that the POLST form is not for everybody. The POLST form is only for people who are at a point in their life where they are dealing with perhaps those three things that could be in that patient's experience at that time. So it's time to put those decisions into action for them. Does that help?
Yes, thank you. That's what I wanted to make sure we were clarifying on the recording.
Okay, good. Okay.
Also, the POLST came in 2009 to be used. It has not been that's only been 11 years. And there are still physicians who do not understand the POLST or do not even know that it exists. So that's part of why the coalition exists, is to continue to do this education, not only in the public, but with our healthcare partners.
Thank you for clarifying that, Terry.
So, any other comments or questions?
Yeah, this is Jazz.
Hi, Jazz.
Hi. I also interpreted Lindsay's question a little bit differently in terms of, I thought maybe she was asking, well, how did it come about that everybody gets attempts at resuscitation? And Diana and Laura, correct me if I'm wrong, there was never any legislation to this effect. It just kind of became the standard of care. And then medical providers basically will consider themselves obligated to operate at the standard of care unless they have specific permission to do otherwise. And that's exactly where the PULSE form comes in.
I agree. I think that physicians are obligated, and maybe Anne, you can also address that as well.
Yeah, one thing that I found curious, Diana, as you were talking about some of those cases in the 70s and 80s, that it seems like the tone at that time from the medical side of things was the doctors, the hospitals were advocating for continuing the ventilator, continuing to keep the feeding tubes in. And, I would say there's been a shift, at least in physicians that, have been educated and come out of training in the last 15 to 20 years. I think the tone has shifted where there are people now working in the hospital who are advocating for not doing those things. And our conversations with families seem to center more on, families wanting things to be done, are advising that these are futile things to do. And that's a real shift from what it was in the 70s and 80s. So I don't know if anybody wants to comment on, how does that impact how older physicians have conversations with their patients versus how younger physicians have conversations with their patients.
Well, and don't you think that shift happened because in the 70s, it was also newer. It was to be able to prolong life and save life and have all these, and as a doctor, or I'm assuming like that's your goal, right? Is to do whatever it takes to make the patient better to the best of your ability. And so these were new things. And so they wanted to, it was new to be able to put somebody on a vent, right? For 10 years. And we weren't doing that in the 50s and 40s as much. Like it's something that kind of evolved and became newer. And then I think as they watched it happen, they realized how much harm could come from that and that wasn't always a beneficial thing.
I think it had a lot to do with the paternalistic view of medicine at the time also. Doctors were doing their best. And, even just a decade or two before, like I said, there were none of these advanced interventions. Doctors kind of came at a clash between knowing what to do best for their patients and these new interventions that came along. People were siding with technology. And if you think about it, all three of these women were young. They were previously extremely healthy. So those are your best candidates for any potential for recovery. And I think it just snowballed from there to where even when the hospital refused to follow out the orders, it was because they had never been put in that place to initiate these new interventions and then withdraw them. Before, patients would just never have the interventions initiated and then patient would die. So it was a whole different change in mindset of how do we trust what we've always done in the past for what we see for the future. And these were very young people who had the best opportunity of anyone to recover.
Well, and we go beyond that, Diana, everybody, is that in that same picture, we're talking about CPR, life-saving techniques, but dialysis was also becoming, I think, we were just beginning to set up dialysis centers. That was a whole new gambit going on. There were organ transplants that had not been happening, and now we were transplanting organs, and that was being more successful, including the heart transplant. So it was hard for the medical system to realize that not everybody was going to benefit from these new science technologies that were occurring.
And then the controversy over, what happens when people decline because of things you're doing, and what's your obligation to continue to treat them because they've had complications from what you've done.
Yeah.
You take someone for surgery and they arrest during surgery, are you obliged to, even if ahead of time they said, I don't want to be resuscitated, well, their heart is now stopped because of something you've done to them, and what's our obligation to bring them through that. Or, you can extend that to complications to dialysis and infected fistulas. And, where do you draw the line of this is now the patient's right to decide versus we've done something to harm you and we need to fix that.
So that leads us to the idea of having conversations no matter what our next medical step is. If I need to have a surgery, I need to have a deeper conversation with my physician than just the surface of what's going on. If something were to go wrong, and actually that's what led me to do my first advance directive, was I was going to have a shoulder surgery. What if I didn't come out of that anesthesia properly? Because that does happen. That led me to my first advanced healthcare directive. So those conversations about what if this happens needs to occur. And it needs to happen with our families long before that. These conversations about end-of-life goals and planning need to begin when we're younger and not just as we are aging. So that will be something for us to look at in the future. And do we have any other comments on this area? I see you're up there, Laura. Were you wanting to speak?
Laura Zempel?
Yes.
No, I'm just listening. Everybody's saying wonderful things, and I agree with all the comments that are being made.
Okay. So I don't see any more comments, and I have nobody else up here to speak. So I'm going to ask Andrea Gallagher. She has a marvelous way of putting things. So I'm going to ask her to speak about our September general membership meeting and what our plans are for the coalition in regards to the ability to attend those membership meetings.
Diana, can I ask that you unshare your screen? There, thank you very much. Now we can see everybody better.
Go. You're just seeing my little static picture there. I apologize for that. But so our next meeting is actually going to be about how to have early conversations. And we're going to touch on differences in conversations as they apply to different generations, different cultures, the LGBTQ population, family pushback. And really, it's why is it so hard to have? That will be the general gist of the conversation. Understanding the emotional and cultural aspects in talking about end of life or life goals. And Terry, you said the September meeting, but I think this one's August 25th. Is that correct?
Oh, that's correct. My apologies. Yes, it is.
That's okay. I thought maybe we were going dark in August, but we're not.
I'm going to Michigan, but I'll be available. So
there we go. So I do want to say personally, Diana, that was amazing, amazing presentation. I learned so much. And it really has helped me to put into context how all this happened. And now I think the next step in series, if you want to call it that, is let's talk about the conversation itself and why it's so hard to have. And our intent is to have speakers that span multiple professions, social worker, chaplain, Lindsay's going to be speaking. And so as I mentioned, that's August 25th. Now we are going to start to make a change because we are trying to really drive some wonderful content for our members of VCCCC. So the way it's going to work in the future, if you are a member of VCCCC, meaning VCCCC, meaning that you've paid your $100 and you are a member, then that's great. If you're not a member, to attend these monthly seminars now, there will be a $25 charge per seminar. However, we have a great deal for you if you're interested. For those of you that aren't members, you may sign up for membership. It's $100 a year. Normally, it's January to December. But what we're going to do is offer a one-time special. If you sign up, if you're not a member and you sign up before August 15th and pay your $100, we will grandfather you all this year and all next year. So you actually get, a year and a half almost of membership for the price of a year's membership. And I think you can see if you're on the call today, you can absolutely see the quality and standards of the presentations and information that we're going to bring forward. And I think also that the conversation that happens after the presentations is some of the most valuable also. So being part of this group, being part of what we all have to offer here is a tremendous value for $100. I hope for those of you that aren't members, that you'll consider doing that. So the Zoom next time will have a registration fee associated with it unless you check the box that you're a member. So with that, I'm going to turn it back to Terry and say thank you, everyone.
Thank you. I really appreciate your attending today. Again, thank you, Diana. That was amazing. And I do want to let people know I recorded this. I don't know how well it turned out, but I'm hoping for my first time it turned out well. I learned from a recording that we did on a interfaith meeting that my husband forgot to put it on speaker mode. I did that. So Diana, you were there most of the time. You were speaking with the slides. So I'm hoping that will work out. So I'm going to try and post it again on our website. No promises, but we're going to work at doing that. So thank you for attending. Please plan on joining the coalition and being a part of us. And oh, Lindsay wants to know what our membership fees do. Well, they help to pay for having this Zoom meeting and to have somebody who can do the constant. They help us do our advertising and promote all educational events, because that is what our mission is, mainly to promote educational events. And then I have a question from Mandeep. Are you unmute yourself, Mandeep?
Hi, sorry, I was supposed to bring this up earlier, but I just wanted to see